Hello and welcome to Courts This Week by LiveLaw. I'm Debojit and this is Advocate Ostika Das. Over the next few minutes, we'll take you through the biggest courtroom developments of the last week, the judgments, observations, and exchanges that could have lasting legal and political impact. So, let's get started. We begin with a dramatic development in the Delhi liquor policy case where the court discharged former Chief Minister Arvind Kejriwal, Manish Sisodia, and 21 others. But Ostika, what really stands out are the court's observations against the CBI.
Absolutely. Special Judge Jitendra Singh did not just discharge the accused, he dismantled the CBI's case. The court said the voluminous charge sheet, running into thousands of pages, was riddled with flaws. Many allegations were not supported by any witness statements. In fact, the judge noted there were misleading averments and internal contradictions striking at the very root of the alleged conspiracy theory.
And what about the allegations against the main accused, Manish Sisodia and Arvind Kejriwal?
On Sisodia, who spent about 530 days in jail, by the way, the court said there was no evidence showing his involvement in formulating or implementing the excise policy and no recovery whatsoever linking him to wrongdoing. As for Kejriwal, who spent about 156 days in custody, the judge concluded he was implicated without any cogent material. The court emphasized that criminal liability cannot be fastened merely on political position or supervisory role. To force someone to face prosecution on conjecture, it said, runs contrary to settled principles of criminal law, where the process itself cannot become punishment.
And according to reports, there were also strong remarks about election spending allegations.
Yes. The CBI alleged that rupees 44.54 crore was used for AAP's Goa campaign. But the court said permitting the agency to independently assume jurisdiction over election expenditure would amount to criminalizing electoral competition. The judge warned that such an approach would arm the executive with coercive instruments capable of influencing political outcomes, eroding the level playing field central to free and fair elections. The court even ordered a departmental inquiry against the CBI investigating officer.
A judgment that goes beyond discharge and raises serious questions about investigative standards and executive overreach. Since then, CBI has filed an appeal already. It will be interesting to watch what will be presented in the appeal now. Our second story this week comes from the Supreme Court, which took a strong exception to an NCERT Class 8th textbook chapter referring to corruption in judiciary. Ostika, the court didn't hold back, did it?
Not at all. A bench led by Chief Justice Suryakant along with Justices Joy Malobakchi and Vipul Pancholi issued show-cause notices to the Secretary of School Education and the NCERT Director asking why action under the Contempt of Courts Act should not be taken. The court prima facie observed that the publication could amount to criminal contempt if it is proved to be a deliberate attempt to scandalize the judiciary.
And this is a suo motu case the court initiated.
Yes. After media reports on February 24th highlighted that the textbook described corruption in judiciary and case backlog as major challenges, senior advocates Kapil Sibal and Dr. A.M. Singhvi raised the issue in court. The Chief Justice of India said judges across the country were perturbed and called it a possible calculated move to undermine the institution.
So, what immediate directions were passed?
A ban of the book. The court prohibited further publication, reprinting, or digital circulation of the book. It ordered seizure of all physical copies from storage, retail outlets, and schools. Any attempt to circulate it, even through altered titles or electronic means, would be treated as willful defiance. The court also noted that the chapter cited complaints against judges in a way that gave the impression no action was taken and said remarks of former Chief Justice of India B.R. Gavai were taken out of context. Though the Solicitor General said NCERT withdrew the chapter and expressed regret, the Chief Justice of India said the press release contained not a single word of apology. The matter will now proceed further and LiveLaw will keep tracking it.
Our third story this week features critical observations from the Supreme Court, this time directed at the Rajasthan Police. Ostika, what happened here?
So the Supreme Court quashed an FIR for extortion registered against Ashish Dave, the former channel head of Zee Rajasthan. The FIR had been filed based on a complaint by Zee Media. A bench of Justices Vikram Nath and Sandeep Mehta expressed shock at how the FIR was registered. Justice Nath remarked that the allegations were as vague as possible, full of omnibus claims without any specifics.
And the court wasn't impressed with the investigation either, right?
Not at all. Justice Mehta strongly questioned whether such an FIR would have been registered if a common citizen had made the complaint. He suggested that the FIR appeared to have been filed simply because the complainant was an influential agency. When the state argued that victims were afraid to come forward, Justice Mehta shot back, "That's also a comment on your police."
What about their treatment of the FIR?
Yes, about that, the court noted that not a single alleged victim was named in the FIR. It said if there's a genuine victim, that person should file an FIR with proper particulars. While quashing the FIR, the court clarified that the state can register a fresh one, but only with concrete details.
Our fourth story brings us back to the Supreme Court's continued oversight of the Manipur violence cases. Ostika, some really bothersome issues were raised apparently.
Yes, the Supreme Court expressed disappointment that members of the three-judge committee appointed in the Manipur violence matter have not received reimbursement for their travelling and boarding expenses so far.
Before we move forward, can you tell us a little about the committee?
Yes, this committee, constituted on 7th August 2023, comprises Justice Geeta Mittal, former Chief Justice of the Jammu and Kashmir and Ladakh High Court, Justice Shalini Phansalkar Joshi, former Bombay High Court Judge, and Justice Asha Menon, former Delhi High Court Judge.
So, a pretty powerful committee. And what did the court decide to do then?
A bench led by Chief Justice Suryakant along with Justices Joymalu Bagchi and Vipul Pancholi directed the immediate release of 12 lakh rupees to Justice Geeta Mittal and rupees 10 lakh each to Justices Joshi and Asha Menon towards expenses. The honorarium, the court clarified, will be fixed separately. The court also directed release of rupees 10 lakhs to Dattatray Padsalkikar, the former Maharashtra DGP who is monitoring investigations by the CBI and Manipur Police.
Our fifth story this week requires a focus on the environment, specifically the fragile Aravalli region. Ostika, the Supreme Court seems to be proceeding very cautiously here.
Very cautiously. The court has said it will first seek expert opinion on whether mining can be permitted in the Aravalli region at all, and if yes, to what extent. Until then, the status quo on all licensed mining activities will continue. A bench led by Chief Justice Suryakant along with Justices Bagchi and Pancholi is hearing this suo motu case. The concern is that a recent change in the definition of Aravalli Hills could open the door to unregulated mining and serious environmental damage.
But what did the court exactly say?
The Chief Justice made it clear. He said, let first experts tell us whether mining can be allowed or not. If it is to be allowed, then to what extent and who will monitor it? We will cross all bridges one by one. The court observed that inputs from the Ministry of Environment, Forest and Climate Change would help clarify what exactly constitutes the Aravalli, its total areas, forest cover, ranges and even areas where towns and villages have existed for centuries.
And there's talk of a new expert body.
Yes. The court indicated it would constitute a high-powered expert committee to examine the definition of Aravalli Hills and Aravalli Range, assess the 100-meter elevation threshold and consider whether regulated mining could be allowed in 500-meter gaps between hills without damaging ecological continuity.
Just for the sake of context, how did this matter reach here?
This matter stems from concerns over a revised operational definition accepted in November 2025, which defined Aravalli Hills as landforms with a minimum elevation of 100 meters from local relief. But in December 2025, the court kept those directions in abeyance, saying its earlier observations were being misconstrued. Now, the court has granted time till 10th March for detailed notes from all sides and will next frame the issues before formally constituting the expert panel.
Our sixth story this week could have far-reaching consequences for how elections are funded in India. The Supreme Court has issued notice on a plea seeking spending caps, not just on candidates, but on political parties themselves.
That's right. A bench led by Chief Justice Suryakant along with Justices Bagchi and Pancholi was hearing a PIL raising concerns about unregulated election expenditure by political parties. Advocate Prashant Bhushan, appearing for the petitioners, pointed out that while Section 77(1) of the Representation of the People Act, read with Rule 90 of the Conduct of Election Rules, imposes strict caps on candidate spending, there are no such caps for political parties. He said that if a friend spends money on behalf of a candidate, it's counted towards a candidate's expenditure. But if a political party spends, that is not similarly regulated.
So essentially, there's a legal vacuum.
Exactly. Bhushan argued that this loophole has allowed money power to distort electoral fairness and equality of political opportunity. He even referred to the electoral bonds case, where concerns about unregulated funding were flagged.
There was some rebuttal too.
Yes. Justice Bagchi raised a sharp constitutional concern. He asked, if the court imposes a funding embargo, won't it trigger Article 19(1)A arguments? What if friends or independent groups fund campaigns claiming freedom of expression through material support? How does the court control that?
But what about the other issues mentioned in the petition?
Yes. The petition also argues that unchecked party spending has led to the presidentialization of Indian elections, with massive funds used to project single leaders potentially undermining the Westminster-style parliamentary framework contemplated in our country. It also notes that expert bodies like the Law Commission have recommended regulating party expenditure and points to countries like the UK, where the Political Parties Elections and Referendums Act 2000 imposes spending limits. The court has now issued notice. If this moves forward, it could reshape the financial architecture of Indian elections.
Our next story rekindles an important question about who gets to enter the judiciary and at what stage. The Supreme Court has now expressed reservations about the 3-year practice rule for entry-level judicial service posts.
Yes. A bench led by Chief Justice Suryakant along with Justices K. Vinod Chandran and A.G. Masi was hearing review petitions against last year's judgment that restored the requirement of minimum 3 years practice as an advocate before joining the judicial service. To recall, in May last year, the court revived this condition, saying prior courtroom experience ensures competence and maturity at the trial level.
So what changed now?
The Chief Justice openly acknowledged concerns, particularly about the rule's impact on women aspirants. He said nearly 60% of judicial officers today are women, and this condition has created anxieties. Girls are really shaken, the Chief Justice of India remarked, noting fears that societal pressures, marriage and family expectations will prevent them from completing 3 years of practice.
And there were some remarks concerning the talent pool available too.
Yes. He flagged the issue of losing young talent, saying that while practice is important, the system must improve and not create a 3-year vacuum that deters meritorious candidates. So the court has now sought responses from Registrar Generals of High Courts on the review petitions.
An important conversation about balancing experience with access and ensuring the judiciary remains inclusive and representative. Our next story raises an important public health question, that is, should all blood banks in India be required to mandatorily conduct nucleic acid test, or NAT? Ostika, can you tell us what the core issue is here and why is it important?
So for context, NAT is a highly sensitive molecular test that detects the genetic material of viruses like HIV, hepatitis B and hepatitis C directly in blood. It can identify infections far earlier than the commonly used ELISA test. And so the Supreme Court is set to consider this issue in March. A bench of Chief Justice Suryakant and Justice Joy Malla Bagchi was hearing a PIL seeking mandatory implementation of NAT testing across all blood banks in the country.
And how come it's not widely implemented yet?
According to the Petitioners' Council, NAT is presently being used in Delhi's government hospitals but not uniformly across India. He argued that NAT can detect a far greater number of infections compared to ELISA. However, the Chief Justice raised practical concerns. He asked about cost efficiency and whether financially struggling states could afford to implement NAT nationwide. He remarked, Delhi can afford. In other states who are struggling to even pay employees, do you want to put another burden on them?
So the case is set for progress after available information.
Exactly. The court asked the petitioner to do proper groundwork, conduct an audit, find out in how many states NAT is available and whether implementation is feasible pan-India. Additional time has now been granted to file an affidavit addressing these queries.
The matter will now be heard on March 13th and the outcome could directly impact blood safety standards across the country. We close this week with a dramatic courtroom turnaround involving the Kerala story too.
Just a day before its scheduled release, on February 26, Justice Bechu Kurian Thomas of the Kerala High Court had stayed the film's release. The single judge observed that even the teaser had prima facie potential to distort public perception and disturb communal harmony. He noted that Kerala, known for communal harmony, could be portrayed globally as a hub of fanaticism and communal divide.
But that order didn't last long, did it?
No. On February 27th, a division bench of Justice Sushrut Arvind Dharmadhikari and Justice P.V. Balakrishnan held an urgent hearing at 7:30 p.m. just hours after the single judge's interim order was published and stayed the release ban. The appeals were filed by producer Vipul Amrutlal Shah.
And what were the arguments for the movie's release?
Senior advocate Neeraj Kishan Kaul argued that it is the prerogative of a storyteller to address social evils and pointed out that even the prequel was not stayed by constitutional courts. He stressed that a film cannot shake religious tenets or disrupt communal harmony and that commercial disruption can effectively curb free speech. Senior advocate Elvin Peter questioned the maintainability of the writ petitions and defended the CBFC certification, noting that 16 cuts were suggested demonstrating application of mind.
And the petitioners had raised concerns about reputation as well.
Yes. They argued that portraying Kerala negatively impacts reputation under Article 21 and even sought removal of Kerala from the title. For now, the stay on release has been lifted. A detailed order is awaited and the case will continue in 2 weeks.
And with that, we wrap this episode of Courts This Week. And as always, for detailed reports, access to court orders and real-time updates straight from courtrooms across the country, visit www.livelaw.in and follow us on all our socials to stay updated with everything that is law.